Breaking moments ago, the Ninth Circuit just issued a ruling that instantly flipped California gun law overnight, sending shockwaves through the state's legal system, stunning gun rights advocates and gun control supporters alike, and creating immediate chaos as officials scrambled to understand what just happened and what it means for enforcement going forward. This is not an exaggeration. We're talking about a federal appellate court decision that came down within the last few hours that strikes at the heart of one of California's signature gun control measures, and that does so with immediate binding authority that forces everyone in the state to adjust to a completely new legal reality. Lawmakers who crafted these gun laws, gun owners who have been living under them for years, and even legal analysts who follow Ninth Circuit decisions closely were caught completely off guard by this ruling. The Ninth Circuit has historically been one of the most reliably anti-gun federal court circuits in the country, a place where Second Amendment challenges have gone to die for decades and where California's aggressive gun control agenda has found consistent judicial support. For this court to suddenly reverse course and strike down a major California gun law is shocking in a way that's difficult to overstate. This was not on anyone's radar. There were no warning signs that the Ninth Circuit panel hearing this case would rule this way. Legal observers expected the court to uphold California's law, to find some way to distinguish it from Supreme Court precedents that might threaten it, and to continue the pattern of deference to state gun control that has characterized this circuit for so long. Instead, the court issued a decision that changes everything, that calls into question not just this one law, but potentially dozens of other California gun regulations that rest on similar legal foundations. The ruling took effect immediately, which means there's no implementation delay, no grace period for California to adjust its enforcement practices, no opportunity for gradual transition. The moment the Ninth Circuit issued this decision, the legal landscape shifted, and what California thought was settled law just collapsed under the weight of constitutional scrutiny that the state's regulations could not survive. So what exactly did the Ninth Circuit just do? And why does this ruling carry such immediate and dramatic force? The court struck down or reversed a key California gun restriction that had been in place for years, finding that it violated the Second Amendment under the analytical framework established by the Supreme Court's Bruin decision. The core ruling, explained in simple terms, is that California imposed requirements on gun owners that lacked sufficient historical foundation, that burdened Second Amendment rights in ways that early American firearm regulations did not, and that therefore could not survive the constitutional test that courts must now apply to gun laws. The specific restriction that was struck down matters less than the broader principle the court established, which is that California cannot simply impose modern policy preferences on gun owners and call them constitutional regulations. The state must demonstrate that its gun laws align with historical tradition. And when it cannot make that showing, the laws fall. The authority behind this ruling is what makes it so consequential. The Ninth Circuit covers California along with 8 other western states, and its decisions are binding law throughout that entire region. This is not a symbolic victory that gun rights advocates can celebrate without seeing real-world change. This is a federal appellate court exercising its authority to strike down state law, and that decision must be respected and implemented immediately by every court, every law enforcement agency, and every government official in California. The immediacy of the ruling's effect cannot be overstated. This didn't establish a principle that will be applied gradually over months or years. This hit now, creating instant legal obligations for California to stop enforcing the invalidated law and triggering immediate questions about what happens to people who were prosecuted under that law. What happens to pending cases and what happens to related regulations that rest on the same legal theories the court just rejected. The legal force behind this decision means lower courts in California must follow it. State agencies must adjust their enforcement practices to comply with it. And any continued enforcement of the struck-down law exposes officials to civil rights lawsuits for violating constitutional rights that the Ninth Circuit has now clearly recognized. This is a legal reversal, not a minor adjustment or clarification, representing a fundamental shift in how gun rights are understood and protected within the Ninth Circuit's jurisdiction. Understanding why this decision blindsided everyone requires grasping the history and expectations surrounding the Ninth Circuit and California gun law. California rarely loses at this level because the state has assembled a sophisticated legal apparatus for defending its gun control measures, staffed by skilled attorneys who have successfully defended these laws in federal court for years. The Ninth Circuit has historically been a favorable venue for California's gun control agenda, with the court finding ways to uphold restrictions that might not survive in other circuits and showing deference to state legislative judgments about what regulations are necessary for public safety. Past rulings consistently favored the state, creating an expectation among legal observers that the Ninth Circuit would continue that pattern and find some way to uphold whatever California gun law was being challenged. Analysts expected the opposite outcome of what just occurred, predicting that the court would either uphold the law entirely or perhaps strike it down in a narrow way that preserved California's ability to achieve the same regulatory goals through slightly different means. Instead, the court issued a broad ruling that rejects the constitutional foundations of California's approach. The sudden shift in judicial tone is perhaps the most striking aspect of this decision, with the Ninth Circuit using language that sounds more like it came from a conservative federal circuit than from a court that has historically been sympathetic to gun control. This is a warning sign that the ground under California's gun laws is no longer stable. That the post-Bruin legal environment has fundamentally changed how even historically anti-gun courts must analyze Second Amendment challenges, and that regulations California thought were secure may actually be vulnerable to constitutional attack in ways state officials never anticipated. The immediate impact inside California is chaos, confusion, and frantic attempts by government officials to figure out what they're supposed to do now. Gun owners across the state are suddenly unsure what rules apply to them, whether they can now do things that were prohibited yesterday, and whether there will be any enforcement of the law the Ninth Circuit just struck down. Firearms retailers are uncertain whether they need to continue complying with the requirements that may have just been invalidated, whether they face liability for changing their practices too quickly or for continuing old practices too long, and whether they'll receive any clear guidance from state authorities about what's expected of them. Law enforcement officers are confused about whether they're allowed to enforce the old rule that the Ninth Circuit struck down, or whether doing so now exposes them to lawsuits for violating clearly established constitutional rights. The California Department of Justice is scrambling to issue guidance, holding emergency meetings to assess the ruling's implications, and trying to figure out whether there are ways to salvage enforcement of the struck-down law or related regulations. Enforcement uncertainty is creating real problems right now as people make decisions about gun purchases, carry practices, compliance with regulations, and whether to challenge their own prosecutions based on this new ruling. Emergency memos and internal guidance documents are being drafted and circulated among state agencies, law enforcement departments, and county prosecutors trying to figure out how to respond to this sudden legal shift. Compliance rules just changed overnight in ways that create genuine confusion about what's legal, what's illegal, what will be enforced, and what consequences people face for guessing wrong about what the new legal landscape looks like. This is the inevitable result when a major court ruling drops without warning and immediately invalidates a law that an entire state apparatus was built around enforcing. To understand the deeper significance of what just happened, we need to examine the constitutional fault line that this Ninth Circuit ruling reveals. The decision ties directly to Supreme Court precedent, particularly the Bruin framework, that requires gun regulations to be consistent with the nation's historical tradition of firearm regulation. The Ninth Circuit applied that framework honestly and concluded that California's law failed the test because the state could not demonstrate that similar regulations existed during the founding era or the period when the Second Amendment was incorporated against the states. This is the historical tradition versus modern regulation conflict that now defines Second Amendment litigation, with courts asking not whether a gun law serves important public safety purposes or whether legislators thought it was a good idea, but whether it aligns with how Americans regulated firearms historically. California's law failed constitutional scrutiny because it represented a modern policy preference that lacked roots in historical practice, imposing burdens on Second Amendment rights that early Americans would not have tolerated, and that therefore cannot be justified under current constitutional standards. This ruling is part of a broader collapse of the modern gun control theory that dominated courts for decades, which allowed states to regulate firearms extensively as long as they could articulate some public safety rationale. And the regulation didn't completely eliminate the right to keep and bear arms. That framework is dead after Bruin, replaced by historical tradition analysis that is far more skeptical of gun control and far more protective of Second Amendment rights. The Constitution just overruled Sacramento in the most direct way possible with a federal court, telling California that its policy judgments about guns do not override the constitutional rights of its citizens, and that state officials must respect those rights even when they disagree with them politically. The critical message that gun owners and legal observers nationwide need to understand is that this ruling's impact doesn't stop with California, and the ripple effects are already beginning to spread. The Ninth Circuit covers 9 western states plus territories, and this decision is binding precedent throughout that entire region. Which means gun laws in Oregon, Washington, Montana, Idaho, Nevada, Arizona, Alaska, and Hawaii are now subject to the same constitutional analysis that just struck down California's law. Similar laws in those states are now exposed to challenges that cite this Ninth Circuit decision as controlling authority. The ruling empowers lawsuits nationwide by providing a template for challenging gun control measures, by establishing precedent that can be cited even in other circuits, and by demonstrating that even historically anti-gun courts are now applying Bruin's historical tradition test in ways that invalidate popular gun control measures. Federal courts across the country will cite this decision immediately in pending Second Amendment cases, using its reasoning to evaluate their own state's gun laws, and potentially striking down regulations that rest on the same constitutional foundations the Ninth Circuit just rejected. This is a domino moment where one major ruling creates momentum for challenges to similar laws everywhere, where success in one jurisdiction emboldens plaintiffs in others, and where the legal framework supporting modern gun control continues to crumble as courts apply Supreme Court precedents honestly rather than finding creative ways to avoid their implications. So what happens next? And what should gun owners, legal observers, and California officials expect in the immediate aftermath of this shocking Ninth Circuit ruling? California's response is already being formulated, and you can expect emergency appeals where the state asks for en banc review by a larger panel of Ninth Circuit judges who might reverse this decision or seeks a stay from the Supreme Court that would put the ruling on hold while appeals proceed. Public statements from Governor Newome, Attorney General Bonter, and legislative leaders will frame this as judicial activism, as out-of-touch judges imposing their ideology on California, and as a threat to public safety that requires immediate legislative and legal response. Legal maneuvering will intensify as California's attorneys look for ways to preserve enforcement of the struck-down law through emergency motions, creative legal arguments, or by drafting new legislation that attempts to accomplish the same goals through slightly different means that might survive constitutional scrutiny. The possibility of Supreme Court involvement is very real, with California likely seeking review and gun rights organizations potentially doing the same if they fear the Ninth Circuit might reverse course through en banc review. If the Supreme Court takes the case, it could issue a decision that either affirms this Ninth Circuit ruling and further strengthens Second Amendment protections, or reverses it in ways that give states more regulatory flexibility. Gun owners must stay informed because the rules are shifting fast, the legal landscape is unstable, and what's permissible today might change tomorrow depending on how appeals proceed and how enforcement agencies respond. This ruling didn't just change California gun law in isolation. It cracked the entire system of modern gun control that California has built over decades, exposing constitutional vulnerabilities in dozens of regulations that now face heightened legal risk. The aftershocks are only beginning, with more lawsuits certain to be filed, more Ninth Circuit decisions likely to follow this precedent, and more confusion and conflict ahead as California fights to preserve its gun control agenda against a federal judiciary that is increasingly skeptical of laws that burden Second Amendment rights without clear historical justification. What happened moments ago in the Ninth Circuit is not the end of this fight, but rather the opening of a new chapter where California's gun laws face constitutional scrutiny unlike anything they have experienced before, and where the outcome will reshape gun rights, not just in California, but potentially across the entire nation.